meaning. And without further ado, Professor Marrus.
Thank you so much, Professor Rowney. Ladies and gentlemen, good morning. Let me begin with my word of thanks to the organizers for putting me in this position, the position of presenting part of the opening session to you, but very importantly, the position of sharing the platform with Henry King. I'm so honored. You do me a great honor by putting me here, and I want to salute Henry King for his address, for his participation, for the chain of connection that he presents to us with those events at Nuremberg more than 60 years ago. Thank you very much. Now, Henry King talked to us just now about the idealism of Nuremberg. What I want to do is to talk about how difficult it was to get this trial off the ground. That will be my focus. How difficult it was to mount the Nuremberg trial. Just a few weeks ago, I found an address by Robert Jackson addressing this very issue. It was an address that he gave to the Alberta Law Society in Edmonton just a year or so after the Nuremberg trial, and he outlined what I think has become a familiar set of obstacles which had to be surmounted in order that these trials begin. There were 4 different legal systems. There were 4 different languages in which the prosecution had to take place. There was no codification of applicable law. There was a great mass of documents that had to be digested and classified and ordered into the prosecution. And all of this in very little time. And all of this in a Germany that was utterly disrupted as far as transport and communications. And further, that the trial should take place. First of all, it wasn't clear where it was going to take place, but when Nuremberg was determined as the site of the trial, that the trial was to take place in a city that was completely flattened by aerial bombardment during the latter part of the war. And so to have done all this, to have surmounted all of these obstacles, and to have achieved what is now known as the Nuremberg Standard was a really extraordinary achievement. But Jackson's address and my outline just now of the obstacles neglected one important dimension of the difficulty, and that is the dimension that I want to talk to you about this morning. And that is the political obstacles in the face of mounting the Nuremberg trial. And so that is what I want to focus upon in the little time that I have, and in order to help me focus and bring this within the time frame that I have, let me focus in particular on the London Conference of 1945, the conference that ultimately produced on the 18th of August, on the 8th of August, the Nuremberg Charter. So, to begin with a few words of background. The first and obvious point, evident to any student of Nuremberg, the negotiations were driven by the United States and by its chief negotiator, Robert Jackson, in particular. Robert Jackson arrived with his delegation in London on June 18th, 1 week before the beginning of this conference. And I think it's fair to say that the Americans held most of the cards in their hand. Most of the major war criminals were in U.S. custody. The Americans had done extensive preparation for the trial and had the clearest vision, I think, of exactly what they wanted to come out of the London Conference. The Americans had in their possession the great body of documentation for the trial. And the American delegation, of course, was led by the energetic Robert Jackson, who had been in place, appointed by President Truman on May 2nd. Jackson had been hard at work since that time on the preparation of the trial. The British were in a far weaker position. Their delegation was headed by the recently appointed Attorney General Sir David Maxwell Fyfe. But the government, of which he was the Attorney General, had actually resigned, and there was a general election held in Britain on July 6th. And the results of the election, because soldiers voting overseas, the results of that election were not even known until July 26th. And when the results were known, it turned out that Churchill's government went down to defeat. And so Maxwell Fyfe had to be replaced, was replaced towards the end of the meeting by the new Attorney General in the Labour government, Sir Hartley Shawcross. The French were represented by Judge Robert Falco of the Cour de Cassation, and the Soviets by Major General I.T. Nikitchenko, the Vice President of the Soviet Supreme Court, and a veteran of the notorious Moscow show trials of the 1930s. So this was not an auspicious beginning, though you can see the imbalance as far as representation was concerned. The negotiations lasted for 6 weeks, and there were 15, sometimes very difficult, public sessions in which all of the representatives met together. And in these meetings, the result was often an extended dialogue between Robert Jackson and the Soviets, so sometimes the French and sometimes the British. And I want, in order to illustrate the political difficulties in the way of the trial, to take 3 themes and comment on them. 3 themes in those negotiations. First, let me talk about what the Soviet representative Nikitchenko called the character of the trial. What was to be the character of the trial? Well, you've heard from Mr. King an important element of that character, which Jackson indeed insisted upon, that the trial be a fair trial, and that there be provisions in the agreement for the fairness to the accused, and for that matter, that there be provisions also in the agreement for dealing with what was feared possible, namely the disruptive tactics of the accused. So far as I can tell from the official record of the London Conference, there wasn't really any controversy over those provisions for fairness. On the very first day of the conference, Jackson insisted, and I quote, "There must be provisions to assure that these trials will be fair, that the defendants will have reasonable notice and opportunity to defend, and those who are physically present before the tribunal will be furnished with copies of the indictment and given an opportunity to be heard in their defense," and so forth. To which General Nikitchenko replied, "That is all perfectly clear." But that wasn't the end of the story. There was a famous issue concerning fairness, which Nikitchenko raised on the second day of the meetings, in the afternoon of June 29th. And extraordinarily, Nikitchenko announced to the conference that in fact the defendants had already been convicted. That they had been convicted by their own deeds, and that this had been officially registered at the Moscow meetings and the Yalta meetings, and the heads of government had already recognized that their conviction was publicly known. And so the real object of the Nuremberg trial was to demonstrate the basis upon which that conviction had already been established. So this was a serious vision of an alternative to what Jackson had in mind, and as David Maxwell Fyfe put it, it showed that the arguments for the so-called executive action, which was part of the background to the idea of summary execution, these ideas died hard. So Jackson, a few minutes after Nikitchenko declared his view that the convictions had already been determined, Jackson made an extraordinary intervention, which I think bears study and has some pertinence to present-day debates about how to deal with internees on internees from what is known in this country as the war against terror. Jackson said, and let me quote him, "I think we are in a philosophical difference that lies at the root of a great many technical differences and will continue to lie at the root of the differences unless we can reconcile our various viewpoints. As the statement of our Soviet colleagues said, they proceed on the assumption that the declarations of Crimea, that is Yalta, and Moscow already convict these parties, and that the charges need not be tried before independent judges empowered to render an independent decision on guilt. Now that underlies a great deal of their position, and we don't make that assumption. In the first place, the President of the United States has no power to convict anybody. He can only accuse. He cannot arrest, in most cases, without judicial authority. Therefore, the accusations may carry no weight in an American trial whatsoever. These declarations are an accusation and not a conviction. That requires a judicial finding. Now, we could not be parties to setting up a mere formal judicial body to ratify a political decision to convict. The judges will have to inquire into the evidence and reach an independent decision. That is the reason why, at the very beginning, that is the beginning of the conference, the position of the United States is that there must be trials rather than political executions. The United States feels that we could not make public executions. I took that position publicly. I have no sympathy with these men, that is the accused, but if we are going to have a trial, it must be an actual trial. And then, having made this declaration, then came the threat. And it wasn't the only time, as I've heard James Barrett mention, that this threat came from Jackson, the threat that the United States might simply pull out. This issue, said Jackson, raises the question of whether procedural differences are not so great that the idea of separate tribunals for each nation for the trial of its own separate groups of prisoners may not be the easiest and most satisfactory way of reconciling our differences. I do not know, but I just put that forward. As Telford Taylor commented, Jackson remained very prickly. In all probability, Taylor went on, he was making a show of force, but he had a lot of force to show. Point number one. Point number two, let me talk about the blending of the common law and the civil law procedures. Jackson did mention this in his talk in Alberta, but let me say this was not only a technical legal issue, it was a political issue as well, and a very difficult one. And may I also add that I don't think the various representatives, despite the fact that they were fully briefed and instructed about different systems different from their own, that is, the Americans were briefed about the European system and the civil law system and vice versa, I don't think the respective delegations necessarily all got it. That is, that they understood. At the very last day of the trial, on August 2nd, there's this, I think, rather touching and amusing intervention on the part of Nikitchenko. Nikitchenko, whose English wasn't that great, said, "Could you please tell me what you mean in English by cross-examination?" Jackson could be very tough on this issue. Listen to what he said on the second day of the conference, June 29th. He said, "It seems to me we are in pretty good agreement as to the promptness of the trial and as to the kind of substantive law of crimes. On these issues, we have little difference. But in the matter of procedure, we're quite wide apart. We're quite wide apart because of the fact that our legal traditions are so far apart. We will reconcile these differences only with difficulty. While they appear to be merely matters of procedure, they are matters of procedure so deeply ingrained in the thought of the American people that some of the theories of procedure mentioned here could not be supported by us. Whether right or not, I do not attempt to say. Different systems have their own merits. Systems with work with one temperament will not work with another, and no one has been more severely critical than I of the American system of criminal justice. But nevertheless, each of us has the problem of making the results acceptable in the sight of his people, and we shall have to consider procedure in that light. Our interest in the matter is to see that the representations that have been made to our people that this was a criminal trial and was carried out in a criminal fashion are to be followed by the procedure that is appropriate to that kind of offense. And then he went on, basically saying that we in the United States need a certain bottom line as far as the procedure to be followed in this trial. The second point. And now the third, let me say just a few words about crimes against the peace. You know that crimes against the peace was essential to have crimes against the peace as the focus of so much of the trial was a major American objective. Henry King has made this point clear. What I would like to stress now is that this was not at all the way the trial was hoped for on the continent. Especially, I'm speaking about the French and the Russians, who brought to the conference very different objectives. Professor André Gros, who was part of the French delegation, put it this way, and Jackson said that Gros got it right so far as their aspirations were concerned. The Americans wanted to win the trial on the ground that the Nazi war was illegal, and the French people and other peoples of occupied countries wanted to show that the Nazis were bandits. Jackson made his case for this priority on July 25th, towards the very end of the conference. And interestingly, he tried to convey to his fellow delegates the American vision of the trial and how this came out of the American experience of the war. It's probably very difficult for those of you who have lived under the immediate attack of the Nazis, he said, to appreciate the different public psychology of those of us who were in the American government during the war. Our American population is at least 3,000 miles from the scene. Germany did not attack or invade the United States in violation of any treaty with us. The thing that led us to take sides in this war was that we regarded Germany's resort to war as illegal from the outset, as an illegitimate attack on the international peace and order. And throughout the efforts to extend aid to the peoples that were under attack, the justification was made by the Secretary of State, by the Secretary of War, Mr. Stimson, by myself as Attorney General, that this war was illegal from the outset, and hence we were not doing an illegal thing in extending aid to peoples who were unjustly and unlawfully attacked. Now we believed, and the American people believed, just the doctrine that I put into this definition. No one excuses Germany for launching a war of aggression because she had grievances, for we do not intend entering into a trial of whether she had grievances or not. If she had real grievances, an attack on the peace of the world was not her remedy. And now we come to the end, and we have crushed her aggression, and we want to show that this war was an illegal plan of aggression. We want this group of nations to stand up and say, as we've said to our people, as President Roosevelt said to the people, as members of the cabinet said to the people, that the launching of war of aggression is a crime and that no political or economic situations can justify it. And this was presented, I might say, as a kind of ultimatum. For right after making the speech, Jackson flew off to Potsdam, leaving the other delegates there in London. He flew off to confer with the American officials to make sure that he had the authority to take a very hard line on this particular issue. Now let me sum up and close by mentioning two additional reflections on the difficulties and how these difficulties were overcome. It seems to me, and I offer this as a question, and we're going to hear from Francine Hirsch, who will talk about the Russian side of this vision of things, but it seems to me that much of what was achieved in the face of these great political difficulties was achieved because the Soviets wanted this trial to happen. Jackson was deeply distrustful of the Russians, deeply distrustful. On July 4th, in a telegram to the Secretary of State James Burns, he referred to his, and I quote, deep differences with the Russians in legal philosophy and in attitude, unquote. And right up to the end of the conference, he signaled to Burns, and this is to me so interesting, his willingness, even perhaps his preference for pulling the plug if things did not go well. That is, for breaking up the conference. Listen to what Judge Sam Rosenman said to close aide to FDR and now part of the Truman administration. Sam Rosenman said to Burns on July 31st. What happened was that, if I remember correctly, Jackson was trying to speak to the Secretary of State, couldn't get through on the telephone, and so he spoke with Rosenman. And Rosenman then relayed Jackson's view to the Secretary of State. And this is what Rosenman said on July 31st. Note, we're deep into the conference, and in fact only just over a week from the end of the London conference. Rosenman writes, Bob, that is Robert Jackson, Bob has come to feel very strongly that it would be better not to have a joint tribunal because of the difficulty of working with the Russians in the trial. He feels that if the Russians, however, in London, accept the various propositions which we've made, that he's committed to favor a joint tribunal, and he does not feel he can back out of it merely on the ground that it would be difficult to get along. If, however, they do not accede to our suggestions as to definition of a war crime and certain other matters, he will then take the course of having each nation try the criminals in its respective jurisdiction. He was even of the thought that the British, French, and Americans might agree to a joint trial, leaving the Russians out, unquote. Now, was this a bluff? Was this a bluff? It's possible. In my reading of Telford Taylor on this, it's possible that Telford Taylor believed it was something of a bluff. Nevertheless, it went right up to the edge. As late as August 2nd, the very last session of the conference, Jackson seemed to be suggesting that the United States might well go it alone. Failure to go along with the proposals that the Americans had placed, he suggested, now listen, he said, results in a proceeding that is so cumbersome as to be almost unworkable and raise grave questions as to whether we ought to provide for a formal trial, unquote. At which point Nikitchenko, who was under orders from Moscow, Nikitchenko said, we would like to know what Mr. Justice Jackson has in mind. when he says that each party should try its criminals independently. As a matter of fact, said Nikitchenko, we come here authorized to sign an agreement for the establishment of an international military tribunal. We have no powers to sign an agreement saying we do not need an international military tribunal. In the end, the austere and dignified chairman of the meeting, the British Lord Chancellor Sir William Jowett, soothed the delegates and smoothed Jackson's ruffled feathers. Listen to how he did it. I wish I could convey it with the aplomb and the accent that Lord Jowett, the Lord Chancellor had at the time. But he said, no, he said to Nikitchenko, no, I don't think Mr. Justice Jackson means that. He's merely pointing out what we have to bear in mind. Unless we are careful, we may make a procedure which involves such long delays and uncertainty that it really becomes impractical, and we may be driven to separate trials. But we hope very much that this will not arise, because it would be a bad thing before the world after having declared that we should have a joint trial, and we should now declare that we're not going to have it, unquote. And so in the end, there was agreement. A final point, and then I will conclude. It succeeded not only because of all of the work of the delegates and overcoming these obstacles, and not only because the Russians wanted a trial. Let me suggest this as a concluding observation and perhaps for discussion. And it's an observation, I have to say, which comes to me very much with the Saddam Hussein trial in mind. The trial succeeded and overcame many obstacles because not only were the Russians willing to go along, even in a deep sense, the accused were willing to go along. The accused largely played the game at Nuremberg. Even Hermann Goering, who intellectually assaulted the tribunal, he stood up when he was supposed to stand up. He sat down when he was supposed to sit down, and his lawyers fit their case. Tough and obstreperous and even intellectually violent though it was, it fit within the framework, the procedures that had been negotiated in London. This trial was a great triumph of idealism, but I think it was also a triumph of politics. Thank you very much.
I would like to add one point to what Professor Marrus has said. I think it would have been hard to exclude the Russians, who sacrificed 28,500,000 people killed in World War II, and who bore the brunt of Hitler's assault on the Eastern Front. If there was a victory at the time, they contributed very significantly to the victory with men, people, and they were the ones that bore the brunt of the Nazi assault. So it's very important that they be there. I also think that it's very important to internationalize these trials. I think I have some concerns about the Saddam Hussein trial, which I think is a national trial. I think when we get people from different countries to agree on an approach, it has more importance from the standpoint of lasting credibility. So this is just a footnote, and I'm glad that it had us, the negotiations were successful. I think it would have been a tragedy not to have the Russians there. The reason I know this is that I worked on the General Staff case, which is the attack by the German armies against Russia, and I know what the history of that debacle was.
Thank you very much. Professor Marrus, thank you in particular for patience, and both of you, gentlemen, for your economy of effort, because this leaves us a few minutes for questions from the audience. If you have questions, please. What effect did it have?
Well, it had no effect because we cut off at Nuremberg. They didn't have a justice of suspense. I worked on the justice case in part. I didn't spend full time on it. The justice system pretty well illustrated by the film Judgment at Nuremberg, and I think you get a pretty clear view of what it's justice in quotes. It's not justice per se. But I think the important thing here is that we wanted to show the world how a system could be corrupted. I think one thing that you have to look at is we performed an autopsy on Hitler's dictatorship, and we found that there are two things that were lacking in that system that were present in our system, and one was the judiciary, an independent judiciary, and also the press, the freedom of the press. Abolish those two aspects, and you get a dictatorship. And I think it's proven since in history, particularly during the Nixon administration, it was very important that those independent entities be preserved. The separating of powers is very important. It preserves our democracy. Mr. Marrus?
When the various representative sectors of German society were identified for the Nuremberg trial, no one, so far as I know, no one suggested the judiciary. Interest in this subject is a post-war phenomenon, but was not part of the immediate war Nuremberg planning era. What were the concerns when these sectors were chosen? The concerns were what was thought of at the time as German militarism, German aggression, German war crimes. And so the various sectors were chosen to reflect those preoccupations. There was a debate over one sector, but it wasn't the judiciary. It was over German industry. And here the European left and the Soviets wanted a major concentration on big industry and the economic forces that had pushed towards war. And the Allies were a bit less interested in this. And when, of course, Krupp Sr. had his stroke, that essentially meant a falling away of a major theme for exposure at Nuremberg, and it was picked up later.
Well, one point to keep in mind is that I think after he had his stroke, Jackson proposed that his son be indicted, and I think that the Europeans were strongly against this. This was not a ball game where you just substitute one player for another. So it's very important to keep in mind that Krupp was front line, but his physical condition prevented him from being tried, and there was no substitute. We got the industrialists and the subsequent proceedings, which I worked on.
I think we may have time for one more question. Yes, please. About confronting these accused, these notorious accused.
Well, I think that I wrote a book on the main defendant at Nuremberg, Alfred Speer, Two Worlds of Alfred Speer. I got to know him very well at Nuremberg. I talked to him at 5 o'clock frequently in August, September 1946. Speer, he took it very seriously. He had at least professed great remorse about what had been done. He said, "I'm guilty, I did it. I take responsibility. Hitler is not here." But he was the only one. The rest of them Captain Brennan, well, that's not my signature, even though it was. Keitel, I only took orders from Hitler. I'm the head of the Wehrmacht, the chief, I command the German armed forces, but I only took orders from Hitler. I'm not responsible. I had every escape hatch and every out that you could possibly imagine in my personal experience. Sauckel told me he had 12 children, but Sauckel had organized enslavement of 9 million people, which was one of the most monstrous crimes. And many of the people died, too. But he didn't want to die. Stryker was a dirty old man, you know, the type of hangs around playgrounds. So this was the type of people.